Okay, hello everybody. We're going to talk about chapter 10 in the Irony book today, and chapter 11. So, chapter 10 specifically focuses on the court and the court system. We're going to talk primarily about the federal court system. The state court system is somewhat similar here in California, though there's more volume in the state's court system, as we can imagine. Um, I also posted a PowerPoint about the path to the Supreme Court. Please take a look at it because it's very interesting about how we get a case to the Supreme Court. And I always like to say that the Supreme Court is the strongest branch of government, even though it's not done intentionally. It was done kind of unintentionally, where one way to have a law kind of checked that the Supreme Court decides whether or not it's constitutional or not is through a constitutional amendment, and that's very hard to establish. So, if we look at the case of Marbury versus Madison establishes that the Constitution is the supreme law of the land, and that the Supreme Court has the concept of judicial review, meaning that they determine whether or not decisions on court cases are constitutional or not, and they have jurisdiction or they have responsibility over state laws, state constitutions, court decisions, and federal law and the U.S. Constitution. Okay, as we all know, and we saw with the Kavanaugh hearings, the making of a Supreme Court judge can be very political. And we're going to take a quick look at the federal court system. The federal court system starts off with the district courts, and there's trial courts in there, whether it be civil cases, criminal cases, bankruptcy, maritime, and so on. Above that, we have the Court of Appeals, and the only thing that the Court of Appeals can do is they can rehear a case if there's a constitutional question involved. All right, so if in the court case before, if there's a question on the constitutionality of that court case, then it can be appealed. You can't just simply appeal just because you lost. You have to have some type of constitutional question asked. 90% of our trials will end here, and here's a good illustration of the federal court system, where we have the district courts at the bottom. This includes territory courts, tax courts, district courts, which might comprise of criminal cases that violate federal law, FISC courts, court of claims, and then above that, alongside of that, we have state courts, where we all probably have some experience, whether it be criminal, civil, small claims, traffic, which is the most common, or divorce or probate. Above that, we have the Court of Appeals here in the United States, 12 circuits. We live in the 9th Circuit. And above that, at the very top, we have the Supreme Court. So the Supreme Court is the final interpreter of all matters regarding the U.S. Constitution. And one of the key powers that the Supreme Court has is they to determine whether or not they want to hear a case. So if a case is appealed to the Supreme Court, they themselves decide whether or not they want to hear it. So their jurisdiction, or I always like to say their responsibility, is hearing cases out of these circumstances that are listed here. Whether it's a concept arising under the Constitution, or, stuff involving ambassadors or public ministers, or where the U.S. part is a government, or where two or more states are suing each other, or where there's a state and a citizen of another state engaged in some type of legal dispute, or a citizen of different states are engaged. So those are the responsibilities of the federal court system. Usually the state court systems and the federal court systems run independently on each other. We can have federal laws that are different than state laws, as if any of you are in California, we do know with the marijuana law, right? Marijuana is legal here in California for the purposes of medicinal use as well as recreational use, but we still have marijuana illegal at the federal level. So you can have according to the 10th Amendment, you can always have a state law that is different from a federal law as long as that state law doesn't conflict with the Constitution. But the Supreme Court of the United States still has jurisdiction on any cases that come out of state courts. So when we talk about at the very bottom in the district courts, federal court cases can include, include crimes that were committed against the U.S., committed against a government official, crosses state lines, crosses borders, occurs on federal territories or the seas. So basically, if someone is transporting illegal immigrants across the border, that would be a federal crime. If somebody goes and robs a 7-Eleven, that'll generally be a state crime. So usually where the U.S. or its property is involved, or the crossing of state lines, or the violation of some type of federal code can constitute a federal crime. Bank robbery is a good example, since bank robbery can be considered a federal crime in some instances because money that is used by banks is backed by the federal government, so it's under the federal government's jurisdiction. Now, there's some concepts that we need to kind of talk about here, where the concept of whether or not judges should use judicial activism or judicial restraint. Sometimes when we talk about restraint, the president will not be officially advised by the court. I mean, they can be informally advised off the record, but generally there's really no formal way that the court can advise the president on issues, or even Congress. They can't decide hypotheticals. They can't require a law or a rule of constitutional law that's broader than required. And they can't pass up on a constitutional question if other grounds may exist to get rid of the case. They'll try to interpret so it has meaning. All your remedies need to be available in lower court or state courts before the Supreme Court will hear your review. In some instances, the Supreme Court will only confine their decision to what the context of the law is. So if the law is looking at a gun rights issue, they'll only focus on a gun rights issue. Now, sometimes the Supreme Court will enact something called stare decisis, or precedent, right? So if a case has already been decided, stare decisis is Latin for let the decision stand. So that means that the issue has already been decided in an earlier case, and that decision stands and has precedent. Now, we're going to see a real big argument come up in the next couple of years of Roe versus Wade is expedited to the Supreme Court. Or let me back up. If some of these abortion decisions are decided in the lower court systems and then eventually elevated to the Supreme Court, Roe versus Wade, which is precedent with regards to abortion rights, can be reheard. Even though precedent has said that women have an inherent right to privacy, including the right to get an abortion within the first trimester, generally precedent will take place, but it's not something that's written in the Constitution or written in law. Another thing that we kind of try to take into account when we talk about the court system is the concept of original intent. Should we be able to take the values of the founders as expressed in the text of the Constitution and apply them to current conditions, which I think is going to kind of be a little bit difficult. And when we talk about the Supreme Court, is there instances where we rely on judicial activism, and maybe with the concept of believing that maybe justices should wait for court cases to come to them. Now, when we come back and kind of go forward in this, and we ask ourselves a question, do we rely too much on the courts, right? We have more than 1 million lawyers in the U.S., over 250,000 cases begin in federal court each year. Only 10% of them go to trial. The Supreme Court receives about 8,000 appeals each year, but they only hear about 200 cases. So that's an interesting thing. Remember, in order for the Supreme Court to hear a case, 4 justices have to agree to hear a case. Plea bargaining, making special arrangements for criminal defendants to plead guilty in exchange for reduced charges. Sometimes these are both beneficial to the defendant and also to the courts and also to the prosecutors. But then again, I would encourage you to watch that CBS video I posted about plea bargaining and mandatory minimums and some of the things that come out of this. Okay, so when we talk about the structure of this court, once the court decides to hear a case, once the Supreme Court decides to hear a case, they issue something called a writ of certiorari, or an order to have all lower courts send the documentation to the Supreme Court in order for them to decide whether they can review the case with that information. And here's a little bit about the Supreme Court process. I want you guys to kind of take a look at this in establishing precedent. Now, when we talk about some famous Supreme Court decisions, I have some listed here. Plessy versus Ferguson established a separate but equal doctrine. Brown versus Board of Education eliminated the Plessy decision and desegregated schools. Griswold established a right to privacy, which you're going to hear a lot about when a lot of these abortion laws are heard. Roe versus Wade upheld the right to privacy, which also gave the women the right to decide what to do in the context of. Sorry, I had some technical difficulties right there. In the concept and what they can do with regards to abortion within the first trimester of the pregnancy. Mapp versus Ohio establishes the exclusionary rule, meaning that the Supreme Court has decided that if law enforcement obtains evidence through an illegal search violating our Fourth Amendment, that evidence has to be excluded from trial. Gideon versus Wainwright were all entitled to a criminal case, an attorney in a criminal case, and Miranda, which establishes our Miranda rights. And here's a couple of ones that I thought were interesting. Gitlow establishes something called the clear and present danger standard. So if we have a free speech case, and if that speech causes a clear and present danger, is not necessarily protected by the First Amendment. Miller versus California establishes some standards where you can determine whether or not something is obscene. Lemon versus Kurtzman basically says that you can't fund non-public, non-secular education through public dollars because that is a violation of the First Amendment. Mapp, which we talked about, Gideon, and Miranda, Griswold, and Roe. So read up a little bit about these cases. They're very brief. They're very the PowerPoints are really concise, and I think it's interesting to kind of understand what these cases involved. Okay, so what we're going to do next is we're going to talk a little bit about Chapter 11, and Chapter 11 focuses on the federal bureaucracy, right? So the federal bureaucracy is basically non-elected officials that kind of perform a service for us, as far as things that customer service wise that the government can do for us. Bureaucracies can be Social Security Office, Veteran Affairs. But when we talk about people getting hired in these type of jobs, the Pendleton Act of 1883 kind of reformed the way that jobs were given out to people. Originally, jobs were given out to people based on patronage. If you supported a candidate, then they would reward you for that support by giving you a job in government. Now, what happens is that for a lot of these lower level government jobs, people are awarded these jobs based on merit. So as you know, you have to apply, you have to go through an interview process. And usually your hiring will be based on your experience and your merit. If we go and look at some of the organizations of the Washington bureaucracy, we have the cabinet, which is consistent of the secretaries of 15 executive departments and the vice president here in the U.S. So that's like the Department of Defense, the Department of Homeland Security, the Department of Interior. In addition, we have the National Security Council, which is comprised of the President, the VP, Secretary of State, Secretary of Defense, and Secretary of the Treasury. And they basically advise the President on security policies. We have the OMB, which is the Office of Management and Budget, which prepares the budget. The president will also control the bureaucracy by appointing heads of these departments. Appoints about 2,500 people to control the Washington bureaucracy. We'll also talk about the budget, and the president will prepare a budget with help from the OMB, and then send it to Congress for Congress's approval. When we talk about spending and some of the cases of spending, we spend most of our budget. A lot of people think it's on military, but most of our budget is going to be spent, or a majority of the budget is going to be spent on Social Security and Medicare, right? So 60% of what's called entitlement spending is spent on such thing as Medicare and Social Security. And should we cap these entitlements to rein in future spending? I mean, there's kind of a belief that we should, but what are those spendings going to be? I mean, what are those caps going to be, and how are those caps going to be initiated? Now, our budget has put the government at close to, now this slide says $17.5 trillion. Now we're up to about $22 trillion in debt. And when we talk about the ways that federal government will finance itself, it's usually through two ways: through taxes and regulation. So when we fund ourselves through taxes, this is the breakdown of how taxes are for the most part allocated. Talks a little bit about federal income tax. I'm not going to try to act like I know the whole details of the federal income tax system, because I don't, and I wouldn't even really want to try to explain it and be incorrect. Now, the second part, that the way government generates revenue is through regulation, right? Through fines that on businesses that could protect the consumer, that could protect the employee, and so on. Regulations are developed, I think in most parts to protect the consumers and to protect employees. If we look at some of a lot of these other government programs that regulate the economy or regulate businesses, or pass out rules in order to make sure an employer is not violating or not exploiting an employee. We have the Equal Opportunity Commission, which provides investigations and directives if someone is believed they're being exploited or believe that they're being discriminated against in the workplace. OSHA protects people's health and safety in a government organization as well as private organizations. And the EPA will pass out fines to businesses that violate their standards and their laws. Now, when we talk about the hidden costs of regulations, who pays for regulations? That's a very important thing to understand. Three people pay for it, or three entities will pay for it: businesses, employees, and consumers. So generally, if there's a burdensome regulation that is passed on, it'll be passed on from the business, who have to pay maybe more in taxes or more in regulation fees. Employees might not get as much maybe benefits or wages in that organization, and eventually the cost of doing business is passed on to the consumers. Now, when we talk about deregulation, that is, the thought that maybe we should relax regulation a bit and have businesses not be so regulated. Is kind of a two-edged sword on this. But I mean, the belief is that if businesses aren't being regulated, they could use that money that they're paying out to be more innovative. So we're going to go ahead and stop there. Go ahead and take a look at this. Also, I have here links that could tell you how much a speeding ticket costs you potentially, and some of the some of the revenue that is generated through the California bureaucracy. And should we go to a system of privatization? We'll look at that when we get into federalism a little bit more and talk about the divide of powers within the government, and then maybe we'll talk about the concept of privatizing the judicial system or privatizing prison system, which is very, very controversial. Okay, so we'll go ahead and stop there. If you have any questions, please let me know.